Ladies and gentlemen, good evening and welcome to the April 8th, 2024 meeting of the Rockingham County Planning Board, meeting I now call to order. Let the record show that a quorum is present to conduct the county's business. So, Jeff, could you handle the invocation?
Yes.
Chair calls upon Mr. Jeff Callum for our invocation.
Our Heavenly Father, we thank you tonight for letting us assemble and letting us to come and have a meeting. And we hope that everything we do will come out right. And we hope that we have a good presentation and that we do everything for you in your name. Jesus Christ, amen.
Amen.
Thank you. Next item on the agenda is adoption of the agenda.
Mr. Chair, I make a motion that we adopt the agenda as written.
A second.
Motion has been made and seconded to adopt the agenda. All those in favor, please signify by raising your right hand. All those opposed, like sign. There's no opposition, so the agenda is adopted. The next item is approval of the minutes for the March 11th, 2024 meeting.
Move for approval.
I second.
Motion has been made and seconded to approve the minutes of the March 11th, 2024 meeting. All those in favor, please signify by raising your right hand. All opposed, like sign. Again, no opposition, so the minutes are approved. The evidentiary hearing tonight is a quasi-judicial meeting. That means it's like a court hearing. State law sets specific procedures and rules concerning how this board must make its decision. These rules are different from other types of land use decisions like rezoning cases. The board's discretion is limited. The board must base its decision upon competent, relevant, and substantial evidence in the record. A quasi-judicial decision is not a popularity contest. It is a decision constrained by the standards in the ordinance based on the facts that will be presented. If you will be speaking as a witness, please focus on the facts and standards, not personal preference or opinion. Participation is limited. This meeting is open to the public. Everyone is welcome to watch. Parties withstanding have rights to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Parties are limited to the applicant, the local government, and individuals who can show they will suffer special damages. Other individuals may serve as witnesses when called by the board. General witness testimony is limited to facts, not opinions. For certain topics, this board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts of increased traffic. Individuals providing expert opinion must be qualified as experts and provide the factual evidence upon which they base their expert opinion. Witnesses must swear or affirm their testimony. At this time, we will administer the oath for all individuals who intend to provide witness testimony. If any of you are going to speak tonight, please step forward to be sworn. Please raise your right hand. Do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated. The parties to this case are entitled to an impartial board. A board member may not participate in this hearing if he, she, or he has a fixed opinion about the matter, a financial interest in the outcome of the matter, or a close relationship with an affected person. Does any board member have any such relationship? The parties in this case have rights for any ex parte communication to the disclosed. Ex parte communications is any communication about the case outside of the hearing. That may include site visits as well as conversations with parties, staff, or the general public. Does any board member have any site visits to disclose? Okay. At this time, we're going to ask staff to present our case for this evidentiary hearing, 2024-08, Duke Energy of the Carolinas.
Good evening, everyone. I hope you're all well. It's good to have everyone together again. Bear with us. The PC's doing some strange things, so we're going to kind of keep it streamlined here. We do have a request tonight. It's case 2024-08. It's a special use permit request to establish a new wireless telecommunications tower for Duke Energy Carolinas, located on the Ernest Drive parcel off of NC 65. The general applicant is Tower Engineering and Professionals, but on the construction drawings, there are about 4 or 5 different names of folks, so I'm going to trust these guys to enlighten you a little bit. Tax pin you note here, noted at 160 and 240 Ernest Drive, New Bethel Township, and it's a special use permit. Here's a vicinity map. It's about halfway down 65 between Wentworth and the Guilford County line on the west side. Here's the parcel. It's dually zoned RA and heavy industrial. The heavy industrial portion is home to the Duke Energy Power Peaking Facility. Right now, there is no real development on the RA zoned parcel. That is the area of the parcel where the tower is going to be going according to the site plan. This is just a quick environmental map to demonstrate that there's some protected creeks on the property. They'll have 30-foot buffers on each side. A tower shouldn't have a major impact on that. Of course, we'll make sure it does not. This is just a circle with a very general approximate location of where the tower is going to go. It'll be set back from the road by several hundred feet and set within a forested area from all the information that I've been given to date. This has been the result of a little context. We have 3, perhaps 4 major telecommunications towers in the works. We haven't had any for years, and then we get quite a few. It's kind of the way things work sometimes. There's a very good chance one will be coming up next month. So we've been deep in the details of these, and if you read through the packet and the special use permit requirements for issuing one, there are many, many, many points of documentation that are required: proof of insurance, approval by third-party engineering, site plan, many other things. And I have meticulously gone through, reviewed, and to my understanding, each necessary component of the application has been fulfilled, making it ready for consideration by you guys. I'll let these folks provide whatever testimony they want to. One thing I would like to bring your attention to specifically, in the recent update to the special use permit language for wireless telecommunications towers, we included this specific contingency. Newer towers are being engineered so that they are self-supporting, yet have an engineered breakpoint, for lack of a better word, so that should the tower fall under extreme weather circumstances, a 4-inch ice storm, something like that, it falls on itself. It does not fall completely vertically. So based on that, and based on the opinion of our third-party engineering review, Atlantic Technologies, Harriet Condiles, she felt very comfortable recommending that we can approve an engineered fall zone of 165 feet for this tower, other than what would be the typical for a 300 A 300-foot tower would typically require a 330-foot fall zone. But because of the specific engineering of this one, we're able to bring the fall zone down by 50%. So I wanted to make sure you guys understood that if you're looking at the site plan. Otherwise, legal has signed off on the decommissioning plan and bond. Proof of insurance has been provided. All of the other major points of the permit have been addressed or fulfilled. So I'll be happy to answer any questions.
Are there any questions for Mr. Cochran?
I have a couple. So if we're doing, in this, this break, explain a little bit more about that, because I've heard us talking about it before. Just refresh me on exactly how that functions. And it looks like on the map, there may be some, like, reasonable proximity to somebody else's property. And just how, you know, how would that, if the thing were to fail?
Right.
Come
I
down.
will give my general understanding, and then I believe one of the applicants here can probably explain in a little more detail.
Okay.
So, the older towers were generally designed as either guide, they have the guide wires, or lower self-supporting. But the sort of older self-supporting towers didn't have any sort of engineering in place that would allow them to crumple in a specific fashion. So theoretically, if they fell, they could fall completely like a tree. So that was the fall zone plus 10% reason from any property lines, protected structures, things like that. This one is engineered specifically with, I won't even talk about the details of it, but with mechanisms that should it come under significant stress, it will fall in on itself as opposed to like a tree, which allows us to reduce the fall zone. Theoretically, there would be some sort of extreme chance that if it did buckle and then the whole thing fell afterward, you're still only going to have half that distance. So that's why engineering approval was recommended.
So it basically implodes.
Yeah, sure. That's a good word for it.
And is this is the first one of these, am I correct in remembering this is the first one of this type design that we've heard?
It is the
Okay.
first one that we've considered. Prior to this, there had been much discussion about it before we amended the tower rules, because we were getting communication from several tower companies about these towers that had engineered fall zone, and would that be allowable? And I said most likely as a special condition, as long as our third-party engineer says it's everything looks good, which is the case here, but it's now built into the ordinance as a possibility. Three possibilities: either a full fall zone for a self-supporting lattice tower that doesn't crumple, a monopole, which is the ones you've seen that are just a big pole with the transmitters at the top. They get a 20% reduction in their fall zone simply because of the way they're engineered. And this is sort of a new engineering category for more modern towers. Specifically, this tower is to serve Duke Energy and their, I would say, sort of high priority communication needs. These guys can certainly explain that better than I can, but if you look at the needs justification, there are some very specific reasons why this tower would be appropriate versus forcing them to co-locate on another tower for what they need to do with this equipment. Does that make sense?
Do we know how far this tower will be constructed from Highway 65?
It is, hang on just a second. It's several hundred feet setback. I don't have the setback from the road memorized. The center of the tower is set back off of Ernest Drive by about 170, 180 feet. There's a small little one-story building on the property. I'm not sure exactly what that's used for, but it's set back 353 feet from that. 65 is even further away than that. So I would estimate about 500 feet, probably.
If you look at the scale, it would be about 500 feet.
I think it's about 500 feet, yeah.
Any other questions for Mr. Copeland? Okay, thank you, Lynn.
Thank you. Oh, let me get this up for one of our applicants has some materials he would like to present. I'll leave that there for you.
You three gentlemen are signed up to speak. Our normal practice is to call speakers in the order in which they signed up, but if you'd like to change that for purposes of continuity of your presentation, we can make an exception for you. So the first speaker is Tom Covington.
Yes, sir. Hopefully I have nothing to say.
Would you like to defer to either one of these gentlemen? Okay, and you are, sir?
Remington Jackson. I'm the third one on the speaker list. Good evening, Remington Jackson. I'm an attorney for Parker Poe, and I represent the applicant, Duke Energy Carolinas, in this petition for the special use permit. Hope everyone's having a great day. Thank you for hearing us out on this special use permit. Along, as you've already mentioned, are representatives for Duke Energy, Mr. Tom Covington and Mr. Patrick Bernier. I want to also apologize, I was not able to print out the exhibits that I'm going to be showing you. I can present lecture copies, which is what I plan to do, as well as present copies after this. I just had a very long day, medical emergency, so I still wanted to present something
You
to
were
you.
watching the eclipse, that's what you were doing.
I've been staring right at it. I don't know why.
Don't feel bad, we all did it.
So first I'd start with our, which some of these you may already have copies of, but I wanted to still present them in addition to staff's report. First would be our special use permit application. Let me make this a little bit bigger for you all.
We have that.
And delete this and zoom in. As you can see, one thing I did want to point out is the size of the parcel. It is 81.7 acres.
Just hit cancel.
Okay. Thank you. Outside of that, it also gives our proposed use, which obviously you're all very familiar with. I also wanted to present our statement of need as to why we're proposing this tower in particular, laying out to meet the standards of the special use permit according to your ordinance. In addition to that, we also have a narrative that, in my mind, still also buttresses the statement of need as to why we're asking for this particular tower in particular. Very important in our mind to meet the standards of the special use permit would be the certificate of non-interference, which in particular points out the fact that the modification is, in addition to this site, will not interfere with any public safety radio services, will not interfere with any land mobile radio services, will not interfere with any commercial, personal, medical devices or equipment. Again, meeting the standards of the special use permit according to the ordinance. This is a little bit longer of a document, but again, to meet the, let me see. There, no, stay there. Okay, the structural design report, again, laying out, as staff has already reported, why it's designed the way it is to ensure that it implodes, as has been stated, rather than falling like a tree. This was another report that was created to provide that information to the board. Another study that was performed, again, to meet the standards of the ordinance, to ensure that we are meeting everything that's required for this particular tower. And finally, I also wanted to provide a little bit more information regarding the, regarding the site plan, so you can see a little bit more as to the size of it. Let me see if I can zoom in. So I think staff already pointed out, but you can kind of see where the towers plan on being placed compared to the remainder of the parcel. And the same, let me zoom out for this one. Again, where the tower is planning on being placed in comparison, again, to where the highway is located, and how large the parcel is compared to how the size of the tower will be. These are the documents that I wanted to present to you. Again, I'm sorry for not being able to provide hard copies, but I can provide these electronic copies. And so that for your review, and then we also want to make sure we're open to any questions that you may have. I think staff already answered one of the big ones as to how the tower, if God forbid something were to happen to it, how it would fall in the worst case scenario. If there's other questions that we can answer for you, I will do my best, as well as the representatives for Duke Energy, Carolina.
Are there any questions for Mr. Jackson?
I just got one. This is solely Duke Energy's tower. You don't allow any of the utility company to piggyback on it down the road, right?
So my name is Patrick Bernier. I'm a senior project manager for Duke Energy. I do, the reason we're here for all these towers, we do this, my team does this across our footprint. So what we do offer as far as for 911 services, county services, other utilities, we offer low or no cost leases for that equipment. If we find out early enough in the process, we've actually designed in their loading, so there's no cost to the county of modifying a tower. We have our equipment on highway patrol towers. We have their equipment on our towers. We actually piggyback a lot on their networks. We also, the fall of the tower, like we design these things, are like, we call them, utility grade, right? These are designed to the highest specifications. A commercial carrier may design to risk category 2. We've designed to risk category 3. So that sort of thing. But if the 911 system or the county system, we have hospitals on our towers, and they're all low-cost leases.
But you wouldn't allow general commercial co-locations?
Yes, sir, we can. So we've done, across the footprint, we've had every jurisdiction ask for something different, right? So we've had some jurisdictions that say, hey, you can't have any commercial on your tower. Okay, we'll do that. We've had jurisdictions that have said you had to have 6 carriers. There's not even 6 cell phone companies. But we had to design into our tower 6 co-locations. We've had a couple jurisdictions say, hey, we limit the commercial towers to 130 feet. So everything above that has to be only for Duke. So we've done that. I'm not the real estate guy, but we do mark all of that in our drawings. That's a permanent set. It goes on record so that our internal partner called PeakNet knows the restrictions that you would put on it. So we would, if you want commercial carriers, we can do that. If you don't, we can do that. We can do some hybrid design if you want.
Yeah, my question wasn't meant to suggest that you should do it. It's just that I thought I read in the packet that you probably wouldn't do it for security purposes.
We don't like to. We like to keep these towers
That's fine.
ourselves, but some jurisdictions require it.
Yeah,
We
that's fine.
do require, as part of the special permit, some degree of ability for co-location for other services. It's just built into the permit, but it's not specifically, you must allow 6 commercial carriers and 4 emergency services and that sort of thing. It's just a general statement that co-location of equipment for other companies' towers and purposes must be made available on the tower.
Okay. Any other questions for,
I do. I figured this question would be more in your line. If the tower was going to collapse or it was going to fall, give me a little more detail of what we would see, what would
Yeah.
happen.
So I wish I have like a 4-foot tall model of our towers. It's at home. So basically, if you look at these towers, they're 3-legged, right? So if you're looking straight down on them, it's a triangle. They taper up. They don't taper anymore. They're just straight up. So at a point in the tower, the engineers will design in a 15% reduction in capacity at one specific location in the tower. And we can adjust that in many different ways. So in a design loading, the wind is blowing, it reaches its design capacity and it fails. That location that's weaker will buckle and the top of the tower will lay down on the side of the bottom of the tower. And now what that does is it now reduces the amount of area that the wind can blow on. So now this portion of the tower, although it's getting the same loading from the wind, the top is folded over and none of that gets into the foundation load-wise. And the foundations are designed as like one of the strongest parts, right? It's imagine big concrete foundation underneath these towers. They don't pull out of the ground. They don't, I mean, if.
Basically hinges.
Yeah, I mean, if you can imagine the concrete, you can look up pictures on the internet, it's fascinating. But our towers don't do that. They fold in on itself. If there was gonna be some additional failure, again, like he said, it would, some bolts or something might fail on the bottom. It would topple over in that half already folded position, but it's designed to fold at the
Can I
top.
show them this?
Yeah,
Okay. Just allow me to show you based on one of our exhibits.
Okay.
Yeah, there's the photo in the package. We have that photo. I believe that's it. We do. We have this photo.
Okay.
It's on page 3, or, well, no.
Yeah.
We don't have a 4-foot model available.
right, I was gonna say, it's a great visual aid.
You'll have to use your imagination.
Right.
So just, I'm sorry being nitpicky. How many lights are on this thing?
Okay, so the FAA requires us to light these towers that are over 200 feet or next to an airport. So what you'll see on this tower is there'll be a beacon at the top, and there'll be 2 side markers, which look like the beacon at the top. Their sequence, they're color-coded and flash in a sequence required by the FAA. As designed, we have all of the same beacons on all of our towers, but there's the light's designed to go out and up because that's what the airplanes need to see. So it flashes like white during the day, it flashes red at night.
And how, if you haven't been to the site, how close will this tower be to a residence?
So the building that you do see, it looks like an old house. It's a storage building. Duke bought that when they bought the property, just never tore it down. I can't testify to that. I don't know where the nearest residence is.
Looks like,
Are there any other towers in the general vicinity?
There are 2 within a 4-mile radius. It is a requirement of the needs justification that the applicant let us know what towers are located within 4 miles and why those towers won't be sufficient for what they're applying for. This study found 2 that wouldn't necessarily be sufficient for the type of needs that Duke Energy has because they need a fairly tall tower to carry out the services that they're planning. I would venture, I'm going to look back at our maps, that there's no way that a residence is within 1,000, if not 2,000 feet of this
Okay.
tower. It's pretty far away.
It's in the middle of the woods.
it's in the middle of the woods. Well, and the question was pretty silly, but one time I stayed in a house where the FAA lights came right in the window at night, and they
Oh, fun.
blinked all night long. So that's why it's a silly question, but it comes from experience.
Yeah, and we deal with that, like if there's a malfunction in the lighting system, they default to daytime. We have a national operations center that gets that alarm, and then we dispatch crews out to fix it as quickly as possible.
Your response from the community?
We have had 0 calls, email, or comment.
Any other question for these gentlemen? Thank you very much. So we need now is a motion.
I'll move for approval.
Any further discussion?
I'll move for approval.
A second.
A motion has been made and seconded to approve this application for a Duke Energy Carolinas. All those in favor, please signify by raising your right hand. All those opposed, like sign. There's no opposition, so gentlemen, you're good to go. Pending any further requirements the planning department has. The next item on our agenda is a request for a text amendment which would provide for a committee named by the commissioners to vet the any changes to the language in the UDO. And with that, we'll ask staff to present the request.
Here's a quick note, just so you know, there may be additional permits or approvals needed from DOT, DEQ.
Yeah.
Those things might come, so that's what we'll talk about. The last thing on our agenda tonight is a request from members of the Board of County Commissioners to establish what we are calling a UDO Advisory Committee, a UAC, as a permanent body. As many of you might know, during the process of developing the 2021 Land Use Plan and UDO, there were steering and guiding committees for each one. The commissioners have asked that those same members serve on this advisory committee. Their role will be pretty basic. They would review text amendments proposed either by staff, by the governing board, by anyone, citizens, and offer comment. Those comments will be collected in a semi-formal fashion by email or by visit, something like that, before a matter even gets to the planning board, so that you all would have that information before it gets to you. There's a lot of technicality in it because we have to create a new section of Article 2, define, what the role is, define the duties, define terms and appointments and things like that. So essentially, the Board of Commissioners will officially appoint these people to this committee. Excuse me, similar to membership on the planning board, except it'll be composed of 5 members. Right now, it is the same 5 members, like I said, that were on the 2021 Advisory Committee. They will only review text amendments to the ordinance. They will not review map amendments. Map amendments will come straight to you guys. There's also a fix in the ordinance that I think everyone will be happy to make. If you look on page 2, if required by the Community Development Director, a detailed statement of all other circumstances, factors, and reasonings for the proposed rezoning or text amendment shall be provided but not limited to. We've had some controversy and discussion about this with some of our zoning map amendments. Our process has always been to gather statements from the applicant, either in pre-application meetings or during presentations, as to why the applicant feels it's reasonable and consistent. Staff is responsible for preparing the consistency and reasonableness statement. We prefer it that way because we gather the information we need from the applicant and then structure it in a fashion so that this board can motion for a recommendation of approval or denial, so that the commissioners can do the same motion, so that the commissioners also have a pre-printed, prepared ordinance should it be approved that the chair simply has to sign. It streamlines the whole process. So what this does is clarify what the role of the Community Development Director and staff is regarding how we determine reasonableness and consistency involving the applicant. Does that make sense? Mm-hmm. Yeah. Any questions on this? I'll be happy to answer. Like I said, it's been requested by the Board of Commissioners. We've gone through different iterations of how this might work, and this was the final version that was settled on that the commissioners felt like was the best fit for the UDO and the best fit for what they're seeking from this committee.
Lynn, remind us who those folks are. I just looked at the land use plan yesterday, and I can't remember.
Oh, I know. If you don't work with them all the time, you wouldn't remember. Currently, it's Bruce Snowy, Charles Rakestraw, Gene Robertson, Will Flint, and who am I forgetting? Oh, Matt Smith with Madry and Associates attorney. So it's Matt Smith, Will Flint, Charles Rakestraw, Bruce Snowy, and Gene Robertson. The same 5 who were involved in either both the land use plan and UDO, or at least one of them. And to that, we've sort of reached out to them and let them know that they've all agreed to do this thing and are ready to go. So
Their response was positive.
yes, all the folks who the commissioners said we'd like to appoint, I asked each one of them individually myself, and each was completely receptive to serving in this role. Yeah. Any questions?
I just got one. I mean, and I know all of those individuals, and they'd be excellent for this, but in the future, and I should know this, but I don't, how many townships we have in Rockingham County?
Townships, I think it's around 10 or 12.
Was it that many?
I look at it all the time. It might be lower. It might be actually 8. There's Ruffin, Leakesville,
Yeah, you got Mayo, New Bethel, and
Mayo, New Bethel, Huntsville, Simpsonville, Price.
the point I'm trying to
About
get,
8.
what I'm saying is, I'm fine with the ones you've got. They're excellent. But I think the way this county is changing in different areas, the way they're growing, to have fair representation, to give those people a voice in the future,
Sure.
something you might want to take into consideration. That's just an opinion of mine, though.
Okay.
Because, you know, southern Rockingham County, we all know is changing every day, and the 220 corridor, and
Yeah.
I certainly think somebody ought to have a chance, and they'll have a chance at a public hearing, I guess, to come out and review it.
Yeah, this will be advertised for the Board of Commissioners hearing. It doesn't get advertised for Planning Board, but it does get advertised for Board of Commissioners. And there are folks in the community who are aware that this is being planned. So if there's anyone who has any concerns or feelings, they'll be able to come and speak. But that's a good point, and that is something that we can mention in our report to the Board of Commissioners based on whatever recommendation that you guys make, that there was also the suggestion of paying particular attention to what townships may specifically need representation in the future.
And the one problem that can arise from that, if you make it a strict requirement and it is applied to the planning board, composition of this planning board, as recently as just 5 years ago and moving forward from there, it's difficult to get people in some of these outlying areas to come and participate in the government process. They just don't want to do it. They don't want to give up the time, or they don't feel like they have the expertise, or, I mean, there's a myriad of reasons, but that's why occasionally this board has had as many as 3 different people from, say, Leakesville on the board, and not, it may appear as though, well, why don't we have people from, say, Ruffin or Simpsonville or New Bethel in the planning board? It was hard to find somebody that wanted to do it. And,
It can be a challenge sometimes.
yeah.
There's one thing I found out years ago. We had all these committees that studied issues, and the end result was we wasted a lot of people's times.
Okay, heard. Anybody else, any questions? Okay, thanks.
Any discussion? I think this is something that we really need. A group that can go over the changes suggested to the UDO before it ever gets to the planning board. It'll end up saving this board a lot of time.
In that note, Mr. Chair, I make a motion to recommend the approval of this text amendment based on the consistency determination statements that are included in the board agenda packet submitted during the presentation, and as may be amended, incorporated into the motion to be included in the minutes.
Second.
Motion has been made and seconded to approve the proposal for a UDO advisory committee. All those in favor, please signify by raising your right hand. All opposed, like sign. There's no opposition, so we're going to make the recommendation to the commissioners that they go ahead with this. The next item on our agenda is new business. We have none written down. So we'll move to old business, which also has none written down. And therefore, we shall entertain a motion to adjourn.
So moved.
Second.
Motion made and seconded to adjourn. All in favor, please signify by raising your right hand. Thank you very much for coming. The meeting is adjourned.